This is Lecture 8, Obviousness, Part 2, Implementing the Graham Framework. The agenda for this is really to look at two cases. The first, and by far the most important one, is the Supreme Court case of KSR versus Teleflex. This is the fairly recent Supreme Court case that has set the basic analytic approach for obviousness analysis in the modern era. Although, as we will see, it is not entirely clear exactly what that test should be. And so part of the challenge here in this part of the obviousness analysis is sort of sorting through KSR. Perfect web text is a case where the Federal Circuit follows up on KSR with some of its own twist on the analytical approach. And so for that reason, it's interesting. And then we'll talk a little bit more about some modern applications of 103. What are the current problems, the modern problems, the questions left unanswered after KSR, and so forth. All right, so KSR versus Teleflex, as I said before, is the primary Supreme Court case for the modern analytic framework for obviousness. But let's back up for a minute and talk a little bit more about what was going on in KSR, and in fact what goes on in most important obviousness decisions. And really, obviousness is about figuring out how to deal with the problem of combination patents, right? Almost all inventions are created through a process which has long been known as standing on the shoulders of giants, right? The idea here is that every invention is really a combination of the various knowledge, understanding, inventions, innovations, and so forth that have come before. And so really, all we're doing when we're making new inventions are creating new combinations of old elements. And so then the question becomes, from a patent law perspective, where what we're trying to do with obviousness in particular is figure out which inventions are worthy of a patent and which ones are not. We need to figure out how to do that in the context of the reality that most patents are combination patents involving lots of old items, maybe some new ones or newer ones, but put together in a new way. In the Graham versus John Deere case that we talked about before, didn't have a lot to say on this issue, but Graham, of course, sets the big framework for what obviousness is about, that it's an issue of law with subsidiary factual decisions underneath it. What emerges with combination patents in particular is a hindsight bias problem, right? And the reason there's a hindsight bias problem with respect to combination patents is that very often, once you see the invention made, once you see the combination put together, then it seems quite obvious, right? Once you see 3 or 4 elements put together, then it seems obvious to you that they were put together. They were all in the art prior to the critical date, and then they were put together. And so if hindsight bias creeps in, and this, by the way, has been studied over and over again and found to be, not only an issue with respect to patent law, but just a fundamental part of human nature, that we have a extreme bias towards making things seem simple once we know them and hard when we don't know them. And so the Federal Circuit took it upon itself throughout the 1980s and 1990s and early 2000s to try and figure out jurisprudential tools to combat hindsight bias, as well as bring predictability to the obviousness analysis, because that, as you'll recall from our last lecture, is one of the primary critiques of the obviousness requirement, or non-obviousness requirement at all, is that it lacks predictability. So what the Federal Circuit tried to do throughout the 80s, 90s, and early 2000s is take the Graham framework and infuse it with various tests, analyses, and so forth that tried to, at the same time, be predictable and help avoid hindsight bias. And so there are really three ways that the Federal Circuit developed tools to combat hindsight. One is you carefully define the scope of the prior art. As you remember, in the Section 103 context, you can combine pieces of prior art together as much as you want in order to find all of the elements of a claim that you're trying to analyze. So one way to combat hindsight is to limit the scope of that inquiry, limit the amount of art that is eligible to be combined. Otherwise, given enough time and resources, you could comb through almost any and find almost any patented invention in some potentially unrelated field, right? So by defining the scope of the prior art in such a way as to try and limit it to relevant, similar fields of technology, that's one way of combating hindsight, because you're more certain that a person of ordinary skill in the art would actually have real knowledge of those pieces of prior art. The other thing you can do is just directly restrict the combination of references, right? You can say that you can only combine references in an obviousness analysis under certain conditions. And in particular, the Federal Circuit had said you can only combine references when there would be a teaching, suggestion, or motivation that to the person of skill in the art that they should do that. You can't just effectively use the patented invention as the blueprint for how to combine references. Instead, you have to use the knowledge of one of skill in the art as the blueprint for whether or not the references would be combined at all. So that's, again, another way to avoid the hindsight bias problem, which is to try and shift the analysis to what a person of ordinary skill in the art would understand at the time of invention to combine, rather than looking from today backwards to see what seems reasonable to combine. And then secondary considerations, which you'll recall were established in the Graham framework as sort of this extra piece of the analysis that the Supreme Court talked about, didn't really detail exactly how much it was supposed to weigh into the analysis. The Federal Circuit essentially, throughout this time period, elevated secondary considerations because, in that court's view, which I think is probably correct, in many cases, if they're relevant to the obviousness question at all, and we'll talk about whether they are, because in a lot of cases they aren't, but if they are relevant to the obviousness question, then they're extremely important, right? Because they can really go directly to the question of whether a person of ordinary skill in the art at the time of invention would understand the invention to be obvious, right? So the Federal Circuit played a pretty big role in trying to develop this jurisprudence, right? The Supreme Court essentially exited the field of obviousness in 1976 with the Secreta case. There was really no discussion in those cases of the hindsight. Graham and Adams both had this analysis of secondary considerations, but they didn't really talk about it in the context of hindsight bias, more just as an important piece of the obviousness analysis. So in '82, the Federal Circuit was created and really took upon its mandate to try and manage the law, and particularly since 1990 paid a lot of attention to what it seemed to that court to be an emerging problem of hindsight bias, rendering lots of inventions obvious that maybe shouldn't have been, that maybe one of ordinary skill in the art would not actually have understood to be obvious at the time of invention. Right, so the primary tool was, as I said, this teaching, suggestion, or motivation test, or TSM. The TSM test was relatively straightforward, and it said once you decide what references are available for the analysis of obviousness, you can only combine those references. You can only include them essentially in the list of references that you can use to find each element of the claim in the prior art. You can only include them on the list if they would be if they can be combined, and they can only be combined if there's a teaching, a suggestion, or a motivation for the person of skill in the art for that combination. Now, the teaching, the suggestion, the motivation can come from a lot of places. It could come from the prior art itself, right? A document could say, oh, by the way, you could combine this invention with some other invention, right? It could do that relatively easily. It could be that a person of skill in the art would naturally know this, right? You don't really have to combine water and boiling together to those two references, because people of skill in the art would understand that that combination exists. It might be that the problem itself would tell you to combine the references, and there's several cases of that where there's a particular problem to be solved, and the very nature of the problem would tell the person of ordinary skill in the art how the combination should be done. So this goes on until the mid-2000s, and then starts to become quite controversial, because one of the pushbacks against the TSM test is that it has the potential of allowing too many patents to be declared non-obvious, because it can be a relatively stringent, almost an evidentiary requirement, that you have to find evidence of TSM. Now, the Federal Circuit had mixed cases on how much evidence of TSM was actually required to make these combinations, but the strictness was sort of a sticking point, both with the PTO and with people who thought there were simply too many patents out there. And so KSR happens. The Supreme Court takes KSR and decides it in 2007. The technology in KSR is, as you might expect, relatively straightforward, right? This is a electronic sensor for a mechanical accelerator pedal in cars, and basically replaces the old mechanical sensors, right? So this is basically a combination patent, right? Because it's taking things that are well known, mechanical apparatus that controls throttle in an automobile, as well as electronic sensors, combining those two things together in a way that people agreed is novel, right? Nobody had done this before. Now the question is it nonetheless obvious? Is it obvious to put an electronic sensor in an arrangement such that you can use the mechanical pedal that people are used to and still get nonetheless the electronic sensing benefits that you also want? So I mean, let's talk about this for a minute. So my own view of this case is it is clearly obvious under the teaching, suggestion, or motivation test, right? I mean, it seems to me that the problem that was desired to be solved here, which is to combine electronic sensors with traditional accelerator pedals, essentially tells you how to combine those references of the electronic sensor and the mechanical pedal, and that should be the end of it, right? You should then combine those references. All the elements of the claim are present in the prior art. It's obvious, end of story. Unfortunately, the Federal Circuit disagreed and wrote what was not a very good opinion, saying that the teaching, suggestion, or motivation test was not met because there was, quote, no evidence that a person of skill in the art would find a teaching, suggestion, or motivation, right? And so the Federal Circuit had decided that this was a non-obvious invention, and so it got appealed to the Supreme Court, and cert was granted. So the Supreme Court strikes down the TSM test, sort of, right? So what the court says is that the flaws in the analysis relate for the most part to the court's narrow conception reflected in its application of the TSM test. And then they go on, and this is where they get to the sort of analytics of what they think the analysis should be, right? In determining whether the subject matter of a patent claim is obvious, neither the particular motivation nor the avowed purpose of the patentee controls, right? So on the one hand, that's an obvious statement, right? And it's also an incorrect statement of patent. It suggests they don't understand patent law because, of course, in the obviousness analysis, we don't care what the patentee did or didn't know at the time. What we care is what a person of ordinary skill in the art new at the time of invention, right? So motivation or purpose of the patentee is not the question, right? What matters is the objective reach of the claim. Well, that's not particularly useful. Of course, what the claim matters. If the claim extends to what is obvious, it is invalid under Section 103. Again, a completely useless statement. One of the ways in which a patent subject matter can be proved obvious is by noting that there existed at the time of invention a known problem for which there was an obvious solution encompassed by the patent's claims, right? And this is effectively as much as we get out of KSR in terms of what they believe the analytic approach to obviousness should be for combination patents, is if there's a known problem for which there was an obvious solution encompassed by the claims. Now, in my view, this is completely unhelpful, right? Because it's just it's not even, I mean, when the analytic framework includes the word obviousness in it, then it's not helping you very much, right? I mean, the fact that in order to determine whether you meet the KSR test, you actually have to decide whether it was an obvious solution encompassed in the claims means you're just going in circles, right? In order to determine whether it's obvious or not, you have to determine whether it's obvious or not. So in my view, this is not advancing the ball very much, and nor does this paragraph, to me, make it sound like the Supreme Court actually knows all that much about what it's talking about when it comes to obviousness analysis. Although it seems quite clear that what they did not like about the Federal Circuit's approach was that it seemed what they described as rigid, right? Rigid and narrow. So what they wanted was a broader conception of obviousness than what the Federal Circuit had come up with. And so that is basically KSR, right? I mean, KSR, to the extent there's analytic content to it, it's really this. There's a lot else in KSR that we'll talk about in a minute that's more sort of dicta and suggestions, but really the key movement here was it found the invention obvious because it said the problem of having electronic sensors with mechanical controls was obviously encompassed by the patent's claims. Now, to me, that's not doing anything more than just stating the punchline. That's not really analysis, but the Supreme Court thought it was being helpful. So basically, as what usually happens in these Supreme Court cases, they leave it to the Federal Circuit to figure out how to deal with the fallout. So the Perfect Web Text case versus Info USA is an important case where the Federal Circuit is trying to deal with the new standards set forth by the Supreme Court in KSR and figure out how to make this work and sort of try and follow the spirit of KSR without, as you see, without necessarily knowing exactly what the analytic framework is really supposed to be. So the claim here was a method for managing bulk email, which included the following steps: matching a target recipient profile, transmitting a set of bulk emails to the target recipients, calculating a quantity of bulk emails which were successfully received, and if said calculated quantity doesn't exceed a minimum quantity, repeat it until it exceeds the minimum quantity, right? So the idea here is, as one might say, obvious, which is you keep sending emails to the target recipient profile, to the list, until you reach a number, which is the number that you want, the minimum number that you want in terms of emails to be sent. So the important part about the Perfect Web case is to recognize that what the Perfect Web Court does is allows the use of common sense as evidence of obviousness, right? So this is, rather than require an individualized reference to show all of the elements of the claim, the court allowed some of the gaps to be filled by the knowledge of the person of ordinary skill in the art, and not necessarily the knowledge specifically tied to a particular reference, but instead just the common sense that a person in this field would have about how these systems would work and how they'd be put together. And the questions to ask, I think, after this is, is this consistent with TSM, which in KSR, although the Supreme Court said it was being applied rigidly, the court did not say that TSM was not a good test or a good analytic framework. It just said it wasn't necessarily the only test and it could not be applied rigidly. I think it is probably consistent with KSR. Now the big question is whether or not this allows this allowance of common sense to get into the analysis, whether this is going to lead us back down the road towards hindsight. Is this sort of the first step of backing off of what the Federal Circuit tried to do for 15 years, which is really wring the hindsight questions out of the analysis as much as possible, and get back into this scenario where the analytic framework for obviousness becomes very uncertain and very subject to biases. And if that's the problem, if that becomes a problem, then you worry that the pendulum, which may have swung too far in favor of allowing too many patents out there, might swing too far back in favor of invalidating too many good inventions. And so the question is whether the safeguards of really being certain that there's some sort of common sense link that you can establish, whether that's enough to ensure that hindsight bias doesn't infect the analysis. And I think the answer is we just don't know yet. I mean, this is the direction the courts are going. They're using more common sense. They're allowing more common sense to what they call common sense to be used in the obviousness context. Now, common sense by definition means it's not written. Perhaps it's just then subject to testimony by people who are interpreting what a person of ordinary skill in the art would know as of the time of invention. Again, if that testimony is subject to knowing what the invention actually ended up being, then you've got a potential hindsight problem, and courts are going to have to police it very carefully to make sure that it is not hindsight testimony. But whether they can, I think, is an open question. And so this is, Perfect Web shows you, the direction, the trajectory that KSR starts us on. Obviously, KSR is not that old. It's only 7 years old, 8 years old. So we don't know for sure how far that trajectory is going to go. But Perfect Web is a good example of one way in which the Federal Circuit is adapting to the KSR analysis. Finally, let's turn to a few questions and thoughts about the modern application of non-obviousness. So the first thing to get straight here is, what prior art is appropriate for Section 103? And the basic point here is that all prior art is defined by Section 102, right? So Section 102 is sort of the gateway section. It defines what prior art is, and then Section 103 in the obviousness context deals with how to apply the prior art, right? So publications that are known or used or on sale, prior patent applications by another under the old law, derivation from a prior invention can be prior art, and prior invention by another can also all be prior art under Section 102 and Section 103. So the way I always think about it is that Section 102 is telling you what documents you can sort of put on the table for the analysis. Section 103 tells you how to deal with the analysis. Next question, what's the test, right? What is the test after KSR? I mean, as we talked the last few minutes, this is difficult to discern from KSR at all. It's clear that what KSR wants is an expansive and flexible approach, right? So, the real question then is, well, we know it's got to be more flexible than what they described as the rigid approach pre-KSR by the Federal Circuit. So what does that mean? Are there certain standards? Are there factors that need to be followed, and so forth? As we've said, and we can draw out of KSR, it does stand for the principle that a combination of prior art elements that yields predictable results is obvious, right? So we do know in the combination patents context, if you have prior art elements that have a predictable result, so predictability is part of the analysis in the post-KSR context. And then the Federal Circuit has really been following up on these themes, right? So predictability, if the invention would have been predictable given the prior art, then it's probably obvious. As we've talked in the perfect web case, it's common sense is certainly available as a component of the obviousness analysis. And the creative person having skill in the art, right? It used to be that there was really not a lot of creativity associated with the person of skill in the art, and now the Federal Circuit's talking more about persons having skill in the art being creative and being able to make connections between different types of references, types of problems, even industries to determine obviousness as they go through it. Another puzzle is what happened to hindsight bias in KSR. I mean, the Supreme Court in KSR dramatically downplayed the role of hindsight bias, and at the same time, that was really what was driving almost all of the Federal Circuit's pre-KSR case law. And so it's a real disconnect here, and I think we still don't really know exactly why. It might be that they just don't believe that the Supreme Court, doesn't believe that hindsight's as much of a problem as the Federal Circuit had always believed and always said it was. It could be that the Supreme Court decided that the cure that the Federal Circuit had developed, which is a fairly rigid application of the TSM test, evidentiary requirements and so forth, if that was perhaps swinging the pendulum too far, and so that even though there might be some hindsight bias under the new rules, it was probably better than allowing too many patents to issue. Or could be they just didn't quite get the point of hindsight bias, and they didn't understand how pernicious it can be because they don't see very many obviousness cases. And in fact, the obviousness cases they do see are simple mechanical inventions. And so, KSR is among them. KSR is a very simple mechanical invention that has, a very clear solution once you know the answer that KSR got. And so KSR itself is, I think, a case that's vulnerable to significant hindsight bias, and the court doesn't seem to recognize this. So we are now sort of in an era of the creative person having ordinary skill in the art. This was a major theme of the KSR case, although they didn't specifically say what was to be done with the creative faceta. This is probably ended up meaning that the faceta is now more realistic. It's more of a real person, and thus the obviousness analysis is probably better in some sense post-KSR. But there's important cost to this, because now, without sort of an evidentiary basis for the knowledge of the person having skill in the art, instead what we're going to ask are experts to speculate on what somebody at the time of invention who knew the art well would have known as both in terms of the content of the references, but also in terms of their common sense, their creativity, their understanding of the way that things would fit together. That's asking for a lot of speculation and offers up the possibility that we're going to have a lot less certainty about how these cases all play out than we used to. And finally, the last thing to think about is what's going on with the PTO. One of the most interesting parts of the post-KSR landscape is that the PTO has become much more aggressive about rejecting patent claims for Section 103 than they were before. The PTO in particular felt that the TSM test was particularly difficult for them to meet because it required, for example, evidentiary findings of a teaching suggestion or motivation. And although sometimes these could come from the prior art, often they would not, and where it didn't come from the prior art, the PTO was at somewhat of a disadvantage because really the PTO only has before it the prior art. And so, KSR causes this, I think, because it is now allowing it doesn't require such a strict adherence to those rules of evidence, and allows the person having ordinary skill in the art to naturally be imbued with common sense, among other things. And finally, the PTO has responded aggressively to KSR. It has really moved quickly and has come up with a series of approved 103 rejections that you can see on pages 394 and 95, which offers a pretty broad array of ways for examiners to reject patent claims under Section 103, and probably a much broader array than they had before. So the net result here with respect to the PTO is that we may be getting a better result after KSR from the PTO than we did pre-KSR, because it might be that the PTO has embraced their ability to be flexible and to use the flexibility of the new post-KSR rules to really dig into in some more depth about whether or not whether or not claimed inventions are in fact obvious or non-obvious. And if that's the case, then KSR has probably done a reasonably good job at fixing that aspect of the patent system. Time will yet tell whether it's done a good job of dealing with the litigation end of the patent system. I think I have my doubts there, but we just don't know that yet, because it takes quite some time before these cases all play out. So that's the end of Lecture 8, and I look forward to talking to you again.